Good morning. Welcome to our special meeting of Municipal Council for Tuesday, September 17th, 2024. It's 10 a.m. and welcome to East Gwillimbury. I'd like to call this meeting to order at this time. Madam Clerk and Council, as I have committed to honor 11:45 this morning, should our meeting not be concluded, I'll have to leave and will pass the chair over to Councillor Acting Mayor Roy DiClemente. Are there any declarations of interest? Not seeing any, we will move on to our land acknowledgement. The town of East Gwillimbury recognizes and acknowledges the lands originally used and occupied by the First Peoples of the Williams Treaty First Nation and other Indigenous peoples. And on behalf of Council, I thank them for sharing this land. We also acknowledge the Chippewas of Georgina Island First Nation as East Gwillimbury's closest First Nation community and recognize the unique relationship the Chippewas have with the lands and the waters of this territory. They are the water protectors and environmental stewards of these lands, and we join them in these responsibilities. Item C is deputations. There are none listed on the agenda, so I will move to item D. The focus of today's workshop is development services. Before we begin, can I have a mover for the recommendation? Councillor LaHaye. A seconder, Councillor Foster. Thank you. Be it resolved that the development services presentation dated September 17th, 2024, entitled Development Services Workshop be received. And we will now pass the floor on to General Manager Beijing to introduce the presentation.
Thank you, Madam Mayor. It's my great pleasure to this morning to present the workshop on development services. If we'd like to proceed to the next slide, please. Just wanted to provide a little bit of orientation. This is just a snapshot of the org chart within development services, but we'll highlight the folks that are speaking to this presentation today. We have representatives of bylaw branch, building and planning. Economic development, I note, is also a part of the development services team, and they are going to be coming forward with a presentation and update at the next meeting of Committee of the Whole, and we'll be joined by the Central Chamber of Commerce at that time. So for today's workshop, we've kind of framed it around what we've been seeing in terms of frequently asked questions, whether from residents, from businesses, from members of council. What are some of the things that we tend to be questioned on, or concepts that people are looking to understand more deeply? And we've sort of built the presentation around that, but at any time, should members of Council have questions, we'd be happy to address them, and there will be at the end of each section there'll be an opportunity to field questions, and then certainly at the end of the workshop as a whole, if you wanted to circle back to any of the issues, we can absolutely do that. So without further ado, I'd like to invite our Manager of Bylaw Services, Harinder Singh, to come and share with you some information about the bylaw branch.
Good morning. I'm not sure your microphone is on.
Hello. There we go. Sorry about that. Good morning, Madam Mayor and members of Council. As Ms. Beijing mentioned, I will be presenting the bylaw branch presentation this morning to give you a further insight of municipal bylaw enforcement and what day-to-day operations look like in the field. Next slide. What is the purpose of the bylaws branch? Protect residents, preserve the environment, maintain minimum standards that support quality of life, obtain compliance through education and enforcement, build public confidence. The effective enforcement of bylaws helps to build public trust in local government and institutions by demonstrating that the municipality is active in managing and improving community standards. Next slide. What are bylaws? Bylaws are primary legislative instruments of the municipality in Ontario. These rules are designed to address issues specific to the community and manage various aspects of local governance and daily life. Bylaws can cover a wide range of topics, such as land use and zoning, public health and safety, traffic, environmental protection, public behavior, and business regulations. The town's policies also help direct decision-making while maintaining consistency in municipal operations. Bylaws provide certainty both to residents who know what behavior and what actions are permitted or not permitted, and to the municipality. Enforcement officials know what powers they have to enforce order in their jurisdiction. Next slide. Who is involved in the delivery of bylaw services? Primarily, you have bylaw enforcement officers, we have administrative support staff, we have supervisors, managers overseeing the overall operations, we have internal departments that we work closely with, building, engineering, planning, parks, roads, and fire rescue services. We also have external stakeholders that we often engage with, community groups, ratepayers associations, and business improvement associations. We also work closely with our provincial and federal regulatory agencies or ministries, such as police departments, the regions, ministries such as Ministry of Environment or Ministry of Natural Resources, to name a few. And we also have affiliating associations that relate to bylaw enforcement. Two primary ones that we often deal with are the Ontario Association of Property Standards Officers and Municipal Law Enforcement Officers Association of Ontario. Municipal law enforcement involves multiple stakeholders and partners. We are not subject matter experts. Certain investigations can involve the consultation and review by professionals in their expert areas, such as arborists, engineers, building inspectors, and plans examiners, to name a few. Next slide. What is the role of municipal law enforcement officers? Primarily, they react and respond to complaints, proactively address infractions when on patrol. They conduct investigations. When conducting investigations, if a violation is identified, they're also involved in issuing legal documentation such as orders to comply, and are responsible parties, outlining issues and the required corrective actions. They also oversee remedial work where continued non-compliance continues, such as long grass and weeds. They also attend court and legal proceedings where continued non-compliance is evident and penalties are proceeded with. They also work collaboratively with police and other agencies. Next slide, please. How do municipal law enforcement officers help? They help with the enforcement of bylaws relating to property standards, animal control, parking, zoning, noise, signs, pool enclosures, and parks, to name a few. They monitor compliance by inspecting properties in public areas to ensure adherence to these bylaws. They provide education to residents and businesses on these regulations, helping them understand their responsibilities and how to comply. They may be involved in the enforcement process as well, which can include issuing fines and penalties for non-compliance if necessary. Next slide. What powers do municipal law enforcement officers have? Municipal law enforcement officers receive their authority and powers for inspections, issuing orders and notices and penalties from the Municipal Act, Building Code Act, and the Provincial Offences Act and the Planning Act. This is primarily where the authorities and inspection powers come from. It is to be clear, they have no arrest powers. When conducting an inspection on private property, as per the mentioned legislations, they must have reasonable grounds. They must provide identification and attend during a reasonable time. Inspection is limited to the exterior of the property unless consent has been obtained from the occupier, having informed the occupier that the right of entry may be refused and the entry made only under the authority of a search warrant that has been issued by a justice of the peace. Next slide. How are investigations carried out? An investigation of a complaint or infraction can involve officers only relying on evidence that they collect. Third-party photos may not be admissible. Site inspections, interviews, collecting facts and issues are also means of an investigation. Determining if a contravention of the bylaw has occurred or is occurring. Depending on the determination, issuance of an order to comply may be required in the investigation. In some cases where offenses have already occurred, immediate charges may be warranted. For example, dumping or parking infractions, which are found committing offenses. Next slide. Why doesn't the municipality do something? It is important to understand that the goal of municipal law enforcement is to achieve compliance. Prosecution takes place necessary to support the compliance. The details of a prosecution cannot typically be shared publicly while the process is ongoing. It is not the role of bylaws to punish or to deliver justice. The focus is not punitive. Orders and charges are aimed at achieving compliance. Bylaw officers and elected officials often find themselves being pulled into disputes between neighbors. Understandably, emotions can run high, but the process needs to be fair, transparent, and always focused on achieving compliance. Next slide. Timelines of an investigation can vary based on several factors. Voluntary compliance in consideration of circumstances, and this could be simply someone facing financial hardship. Collection of sufficient evidence. Who, what, where, when, and how. These are primary facts and issues that need to be proved with an investigation to determine reasonable grounds that a offense has been committed or is being committed under the bylaw. Clarification or interpretation of applicable legislation. An example of this is, again, bylaw officers are not experts, so they often are having to reach out to the professionals that are within their applicable legislation to receive that official interpretation. An example is the zoning examiners or planning examiners. Bylaw officers often, when dealing with the zoning bylaw, reach out to the planners to receive official interpretations. Available resources affect timelines of an investigation as well, whether it's software issues, technology, access rights, and staffing resources. Access to a property and authority. Simply as owner refusing an entry, officers often rely on other means of coordinating inspections. Environmental factors, weather, uneven surfaces, forested areas. Reliability on external agencies such as other departments, ministries, and witnesses. Timelines can also include determining jurisdiction, who has primary control of these assets, and what other legislations may be involved in an investigation. Next slide. To provide you with an example of an investigation and its timeline, I'll briefly run through a case study as an example. So of June of 2023, an investigation into a complaint of excessive noise and fireworks was initiated. The number of inspections were conducted were 5. These are found committing offenses, right? So the alleged offenses require either an officer to witness the occurrence or require a witness statement. Due to the nature of complaints, the investigating officer engaged with the concerned residents to obtain witness statements. The investigating officer also met with the occupants of the subject property to advise of concerns received and educate on the town's bylaws. In August of 2023, continued occurrences were reported, and as a result, a Part 1 provincial offense notice was issued. In September of 2023, continued occurrences were reported again, and this time, enforcement escalated by means of a Part 3 charge. A Part 3 charge is a charge under the Provincial Offences Act administered by York Region Courts, specifically dealing with offenses that are considered more serious or complex and require court hearing. In this case, Part 3 charges for the multiple offense dates resulted in a decision by the Justice of the Peace in favor of the town, rendering monetary penalties of approximately $80,000 and plus. To provide you with a timeline, it took approximately 193 days from when the charges were laid in October to trial proceedings in Provincial Offences Court. It took approximately 393 days from the initial complaint to a final disposition, which was earlier this year. Next slide. What are some challenges impacting bylaw enforcement? Inability to contact property owners, inability to access a vacant property due to locked or gated accesses, occupants misrepresenting the facts when interviewed, language barriers, infraction activity taking place outside of currently staffed hours, early mornings, nights, safety concerns when attending a site where potential infractions are taking place of large groups, or alcohol or other substances that are involved, reliance on complainant to provide first-hand account of what transpired to substantiate charges, occupants being coached on what to say to officers when and if questioned. Officers must be careful to refrain from coaching leading the witness, as they have to remain impartial throughout the investigation. Next slide. What it's like to work in bylaw enforcement, a day in the life of a bylaw officer. We have a video to show you all, which provides a really good insight into the role and daily duties of municipal bylaw enforcement. The video is from Alberta, however, the investigation processes and techniques are similar.
Do you like to follow rules? Would you like to make sure people follow bylaws for traffic and animal control? Are you good at resolving conflict? Then you might do justice to a career as a bylaw enforcement officer. Bylaw enforcement officers work for municipalities to enforce local bylaws. Some may also be appointed as special constables called community peace officers. They enforce certain provincial statutes in their areas. To find out the details of this important career, we launched an investigation by talking to a bylaw enforcement officer working here in Alberta.
Hello, my name is Courtney and I'm a bylaw enforcement officer. A bylaw enforcement officer's work varies depending on the municipality that they work in. Smaller municipalities may have more responsibilities, and that could include animal control, parking, business licensing complaints, or weed control. But I work in general enforcement, so I deal with private properties. So I respond to graffiti complaints, complaints about loose litter, long grass, overhanging trees, and snow on walkways. Typically in the morning, I start by reviewing all of the new complaints that I receive. When I receive a complaint, I go through and look at the property history. So I see if they've had a similar file in the past or if there's an open file currently. Once I compile all of my new complaints, I review my old complaints that I'm revisiting, schedule everything onto a map, and then I coordinate my travel for the day. I let our dispatch know where we are and where I'm going to be heading to. So I go and I look for the complaints and I look to validate them and decide at that moment if I'm going to move with more enforcement or if I'm just going to close the complaint because it's not valid. Essentially, our main goals are to investigate, enforce, and educate the public. So we're looking to educate people on the community standards bylaws and what it means to be a part of your community and have a property that meets those standards. So that may look like doing a phone call and explaining to somebody why their property is in violation of that bylaw, or sending them a notice that will help the property owner understand how their property can become in compliance with the bylaws. The work environment is what you want to make of it. It can be incredibly busy. Your area may be a little bit slower, but you have the opportunity to do officer-initiated complaints. So you can walk around your neighborhoods, get to know the community, and see those problems firsthand, and then be able to report and act on them. My working hours are Monday to Friday from 8 to 4, but other municipalities may require people to do shift work, and most of the work is outside and in various weather conditions. So it could be very hot in the summer or very cold in the winter with potential for dangerous driving. Typically, a 2-year diploma with criminal justice is a great asset to have for this position because it lays the groundwork to an investigative position. So whether that's, behind the scenes in an ununiformed position like bylaw, or a public-facing position like police or a peace officer within the province. You'll also need a criminal record check, a valid driver's license with a clean record, and standard first aid. A bylaw enforcement officer may require personal protective equipment depending on the scene that they're responding to. This could look like steel-toe boots for all of our investigations to make sure our feet are safe when we're out walking around. We also require gloves and Narcan if you are in a specific neighborhood. What makes me the most proud about my job is my ability to connect with others and listen and be able to use my customer service skills to build a connection with property owners in the city as well as our complainants and make everybody feel heard. It just makes me feel really proud to be able to connect with the citizens so they know that I value their contributions to the neighborhood.
Bylaw enforcement officers require good judgment, communication, and conflict resolution skills. They should also have an ability to deal with sensitive issues and be good problem solvers. If this sounds like you, you're going to rule as a bylaw enforcement officer. To gather more evidence on this interesting career, including training requirements and salary ranges, go to the occupational profile on the ALICE website. While you're there, check out some related occupations, including Border Services Officer, Correctional Peace Officer, and Conservation Officer.
Perhaps before Harinder continues, I'd just like to note that bylaw officers do not have the power to prosecute bad puns. So.
Excellent. Thank you for that video, IT. Good segue into the next slide. What it's like to be a municipal law enforcement in the town of East Gwillimbury. For this slide, I will call up one of our senior officers, Officer Brian Williams, to run through some of the equipment and tools that he wears on a daily basis and share maybe some of his experiences.
Welcome. Good to have you with us today.
Thank you very much. Thank you, Harinder. Mayor and Council, my name is Brian Williams. I've been a municipal law enforcement officer for approximately a decade now with the municipality. So I have a lot of interesting stories. I won't get into those details today, but we could always have a chat later on if we meet face-to-face in the hallways or we pass. I just wanted to quickly go over our uniform and what we carry. We have marked uniforms. We may look similar to a police officer. We do have ballistic armor. This is for our protection. We do drive marked vehicles, which are clearly marked 365 degrees. They have lighting as well, and this is for our safety. We have name tags. We have a name tag on the back of our uniform. We also have our name displayed on the front of our uniform. We do carry expandable batons for our protection against animals and wildlife. We do work in environments where we have low lighting conditions, overnight shifts, entering into unoccupied buildings. So we do have means of illumination by flashlight. We carry measuring tapes. Measuring tapes are useful for determining survey information to ensure that there's compliance with whatever we're looking at. We do need to measure things. Long grass and weeds are some things that we look at. So the measuring tape is the scientific tool that we use there to ensure that we have the proper compliance or non-compliance. We have safety boots to protect our feet, as kind of mentioned in the previous slide here with our friends in Alberta. We also have safety vests as well, high-vis safety vests to protect us at nighttime and have a visual to ensure that we're visible in low lighting conditions. We do have other items as well, multi-tools, bolt cutters. We have a large toolkit, but these are some of the important ones. The most important thing is, although we do kind of look like police officers, we do the similar equipment. We are not police officers, and thank you very much, Harinder, for kind of bringing us through those slides earlier. But it is important for us to have identification, so we carry that by means of warrant cards or identification cards on our person. We do have the name plates and name tags, and also on the back of my vest today you will see that it does clearly state who I am, so there's no confusion when entering onto properties. Thank you.
Thank you, Brian. Very much appreciated. Next slide, I think that pretty much wraps it up. So at this point, if council members or Madam Mayor have any questions, feel free.
Thank you very much. Councillor LaHaye, go ahead, please.
Thank you very much, through you, Madam Mayor. I do have a question, because as councillors, you mentioned at the beginning, we often find ourselves in the middle of things with residents reaching out to us. So, for example, what is the process when your department is contacted and then you receive a complaint, and so you go out to the property to look at it in person? How many times do you visit? What do you do if you can't access it? Do you send letters to the residents? So, for example, I ask this question because perhaps a resident isn't home, and then they get a letter saying they're being fined or whatever the consequences are, and they say, well, they never knew there was a problem. So, how do you communicate with a resident if you have a difficulty making contact?
That's a very good question. So there are certain processes that staff have to follow, right, through an investigation, right? And there's limitations within the legislations that are enacted, right? For example, the Provincial Offences Act, if there is a offense date, you have 6 months to lay a charge. So the officers have to be reminded to work within that limitation period. So procedure of attending the site, leaving a business cards at a reasonable time, right? And if communication fails at that point, under the bylaw, officers have the right to issue an order or notice of contravention, right, to get the attention of the property owners, right? And they follow a certain process, and then a follow-up inspection after that entails. And if that still fails to have an owner reach out to the municipality or the township in regards to whatever documentation they have received, then unfortunately, officers are still required to proceed in the next stage of enforcement. I mean, there's all reasonable acts that officers are entitled to, carry out before that escalated enforcement approach is taken, and that's, attending multiple times, but with limited resources and staffing, you can only attend a property so many times to say, hey, we're here to educate you on the bylaw. We're here to let you know this is the concern and you need to rectify the issues. And then the next step is obviously through documentation, letting them know, this is what the issue is. You have a certain amount of time to remediate. And if not, the town may seek further escalated action.
Thank you very much. So just one follow-up question. So you leave a business card. Is there, in the little video there, it showed, even though it's Alberta, they showed almost like a door hanger, and then they were filling out what the issue was. So East Gwillimbury, we leave a business card, or is there any other sort of documentation that's left?
We do have door hangers. We do leave those, depending on what type of violation it is, and the environment as well. Some properties may not have the ability to hang a door hanger, and it might be just a business card, and depending on if it's a minor infraction or a more serious infraction and what the investigation kind of involves, right? A business card is a little bit more of a serious type, hey, give me a call. This is, the township attending. If it's a long grass and weeds call and it just may need, remediation, then it might be a door hanger out of courtesy. Can you cut your grass by, so and such date?
Thank you very much.
Councillor Crothers, go ahead, please.
Thank you. On average in East Gwillimbury, how long does it take for bylaw to respond when something comes in through customer service?
So currently, we don't have a standard timeline. Every investigation or complaint that comes in, it's priority based, right? And officers have case volumes already. So as calls are coming in, they get put into a sequence and responded accordingly.
So in general then, on, let's say, a long grass complaint, how long would it take to respond? What is the standard that we can be telling our residents you can expect to get follow-up within what period of time?
I would say right now, with the resources we have right now, 5 to 10 business days seems reasonable. And that too, when I mentioned in the presentation, there are several factors in the investigation. The fact that sometimes we can't get a hold of the homeowners, right? And we leave the business card and that file might, stay in the queue of the officer for another 5 days additional until further action can be, obtained while the officers are attending other calls.
Thank you. It's that first point of contact to know that someone has worked on it. To me, I understand the limited resources, but if someone's calling in a 10-day window, like for someone to even make initial contact, to me is excessive. And I think that's something that we need to be looking at as a town for our customer service standards, that 10 days is too long for a response. I understand you're working with what you have, so I think it's something that we need to resource better. Now, my second question is about after-hours complaints. And that ties into what Councillor Leahy was saying about leaving a business card. A lot of people are out during the day. Are our bylaw folks just working till 4 o'clock, 4:30? Or do we have anyone that can attend when people are home from work?
So currently, they are working 8:30 to 4:30. We are addressing parking infractions periodically when we do have the staffing resources and when staff are able to accommodate a night shift, but it's not as frequent and in sequence, I guess you can say.
So I think as a town, that's something that we need, as we grow, something that needs to be addressed for sure. And then my final question, this has been something that's bothered me since I've been on council, is follow-up. When you get these repeat offenders, and someone's parking on their grass, let's say, and you go out and you talk to them, and they move their car, and the next week it's back on there. So residents have been saying to me that it shouldn't be on them to have to keep calling in every week. But at some point, is there something in your process when there's a repeat offender that's just automatically on your to-do list to keep going back to that house if someone keeps parking on their grass, let's say?
We can. It's just a matter of leaving that file open and for how long, right? We can leave it open for a couple of weeks and monitor. However, we have other priority calls that we need to attend to, and that call can kind of be pushed back on the back burner if it's not closed. And the fact that a new complaint also paints a picture for repeat history, giving the tools necessary for an officer to justify escalated enforcement action at that point.
So I think that's something that we also should be looking into. I would say it's in the top 10 of complaints I get from residents, is that they don't feel it's their job to have to continually calling into bylaw. If bylaw is aware that a resident consistently parks on their grass, let's say, that bylaw needs to escalate it, and it shouldn't be up to the resident to do that. So I think that's another area for improvement. But again, it's the limited resources, I think, that are holding us back.
Absolutely.
Thank
And for the repeat offenders, we do, have the certain few files that we keep open until we receive that full 100% compliance, right? It's not always that we get the full compliance, so files do stay open or until court proceedings, commence and we actually get that compliance from residents.
Thank you.
Councillor Crone, go ahead, please.
Thank you, Madam Mayor. Through you to Harinder. Thank you for your presentation and all the good stuff that you do for the town. I recognize that I may be a source of a lot of your business, and I apologize for that, but you guys do a great job. And I wanted to pick up on something my colleague, Councillor Carruthers, was talking about, and it's something that I think many of us here share. It's the idea of a culture of customer service, and I think we all want to. It's never a job that's complete. You're always, it's a journey. You're always working on it. I'm going to put you on the spot. I'm going to suggest that if, let's say, magically you had 1 or 2 extra staff members, would you have enough business work to keep them busy?
I would say so, absolutely. We would operationally be in a better place to set up certain standards and, like Councillor Crowther mentioned, certain standards of response time to certain calls. We would be in a better position to do that.
Okay, so I would say to my colleagues, and we're on preparing for budget. This is something for us to consider. I think we need to keep in mind. Thank you, Madam Mayor.
Margot, you might have some information as well?
Thank you, Madam Mayor. Just to add to the context, and I think this speaks to the some of the points that Councillor Carruthers raised, is what we are operating primarily on a reactive basis right now within the resources that we have, and having additional resources to sort of get to where we're sort of, our complement matches that of comparator municipalities, but also allows us to be more proactive in achieving compliance, and allows us to focus on things like parking, or have additional coverage through nights and those types of things. So it really does expand our reach in terms of enforcement, and it just comes down to a matter of going beyond just reactive, and being able to be more focused on providing feedback where it's appropriate. We obviously can't share details of a prosecution, but even just having the resources to be able to acknowledge and that action has been taken, I think would make a big difference.
Councillor Foster, go ahead, please.
Thank you, Madam Mayor. Just a statement to start off with. I wonder, I'm not even sure that we do this, and maybe I'm behind the 8 ball here, but do we do any social media, any publication campaigns about certain bylaws at certain times of the year? I'm thinking about some of the phone calls that I'm sure we all get here about parking, about noise, about fireworks, about those types of things. I wonder if that's something that we might want to think about doing in the future. Outside of that, I'm looking at some of the challenges we have with staffing, and it's already been brought up a couple of times here. Maybe I'm a little old-fashioned, or maybe I'm a little of a hard nut to crack, but I would like to see us grow in a graduated way. So as an example of that, we talked about outside staff hour calls. Not that long ago, we were made aware of a possibility of some after-hours work being done, and it was on a Friday night. It is not customer service. It's not good enough in my mind to get that message on a Friday night and expect to wait Friday night, Saturday, and Sunday, and then have someone go out to have a look at it Monday. So part of that growth in my mind is, and please understand, this is coming from a guy who wore a pager for over 30 plus years. Before we start seeing reports about we need 2 more staff members or this type of thing, I would love to see an on-call situation worked out. We can make up those hours somehow with a little bit of creativity with our managers. But I would love to see that report come back and say, in the year of 2025, our on-call person got called out 300 times on a rotational basis or whatever. That's the kind of thing that tells me we need more help. So to me, that's kind of where we start. That's a good place to start. And I mean, a situation of, the one that I spoke about on a Friday night where we think there's after-hours work going on, well, you may expect that it's going to happen Friday night, Saturday, and Sunday. So there needs to be someone out to have a look at that in a hurry. I don't know if anybody can talk to that, but I just wanted to throw that out there.
Communications going to address. Thank you.
There we go. Through you, Madam Mayor. Thank you for the question regarding communications. I'm happy to share that we work very closely with the bylaw team, and I can give you an example of a campaign that ran quite recently. This was regarding illegal dumping. So the bylaw team brought forward to us that there seemed to be an uptick in illegal dumping during the spring and summer months. And so we created a campaign to educate the community, to advise them what to do on how to report, and that positively there are tags that you can get at customer service. And this ran through social media channels, through our digital signs, and through the e-news newsletter. So ongoing, we're working on campaigns to both address what we're seeing out in the community and proactively support residents in understanding our bylaws. I hope that's helpful.
Councillor, go ahead, please.
Thank you, Madam Mayor. Through you, I think most of my comments have been made, but I did want to kind of highlight an understanding that once an investigation has been launched, that there's a reasonable expectation of privacy for the people who are being investigated. But at the same time, the people who have made that complaint often feel like they haven't been heard because they don't know what's happened. And so I think it's really helpful, I think we touched on it briefly, it's really helpful if a complaint is acknowledged. And I don't want to see, again, this is an operational matter, but it seems to me that having a bylaw officer do that acknowledgement is a waste of resource. And if there was an administrative position, whether it's customer service or whether it's the support staff who are supporting bylaws, to simply acknowledge the complaint that a resident has made, to say that it has been received and is being addressed. I think that is a good way of closing the loop with those people and understanding that we can't share everything, but that also helps, I think, address that. It goes into a black hole, and why do I have to keep complaining when it's being addressed? I love the idea that if you complain more, that it escalates, that you keep getting, if you're getting 6 calls about the same thing and you're opening 6 files, then you're going to escalate further and come down a little harder on that bad behavior. Thank you.
Go ahead, Margot, please.
Thank you. Through you, Madam Mayor. I just wanted to sort of follow up on the staffing, and not to sort of this. I think the conversation that we'll have on staffing will be more at the time of considering the budget, but just for context, understanding where we are right now, the municipal law enforcement officers that we have typically have case file loads of 100 cases on average every day. So there is a need to move beyond where we are in terms of service level, and our expectations around service level will require either some things get taken off the plate or we add more resources, and that's where we are. I don't think anybody disagrees with the idea that of being more responsive, of communicating more proactively, of even initiating investigations more proactively. It just becomes a discussion about achieving the balance in terms of what is the service level that we want to commit to.
Thank you. Councillor Johns, please.
Thanks, Madam Mayor. I don't think that there would be any debate over coming from councillors about the recognition that the opportunity to increasing service levels, especially when the response time, calling out the you mentioned business days of 10, which that actually could be 3 weeks. But we very much feel it firsthand when speaking with residents. So I don't think you're going to get a debate from us on the need versus the opportunity. I think it's balancing finances. And in my role as chairing finance, when I am thinking about increasing the operational side, I just wanted to get my head better around the capital side. If we are increasing operational resources, kind of to Councillor Foster's point, are we increasing operational resources at the exact same time? In which case, that means additional folks on the ground means additional vehicles that need to be purchased. Like, I mean, there's a ramification for our operational decisions on that side of the budget, but I'm wondering what the impact would be on the capital side of the budget.
Go ahead, please.
Yes, and thank you for the question. Yes, there absolutely is a capital impact because as Harinder has mentioned, the enforcement officers require vehicles. But I think there's also another component in that more resources also can contribute to more revenue generation. So being proactive in prosecuting parking infractions, just as an example, that generate fines. Well, obviously it's our focus to try to achieve compliance, but fines are a tool that gets used to achieve that compliance, and that can then sort of generate the revenue necessary to offset some of these capital and operational investments. It's very challenging when you don't sort of achieve that that balance to be able to. We're not in a position right now where we can actively pursue some of those revenue generation opportunities.
Just in follow-up and clarification.
Go ahead, please.
Thanks, Madam
Yes.
Mayor. Sorry for speaking over you. The clarification on the revenue generation, and I'm recognizing that we shouldn't be treating bylaws as a profit center, but because going back to the items that should be about education enforcement, but revenue created, I believe, doesn't that strictly go to operations, or how does revenue creation move to the capital side of things in the budget?
So,
Go ahead, please.
so through you, Madam Mayor, the fines that would be received do offset the operating costs. What that might do, though, is reduce some of our requirements for taxation that might be able to help out on the capital side. So indirectly, it might help, but directly, it goes to offset the operating costs.
Sorry, to be clear, revenue generated does not go to capital.
Correct.
Councillor Carruthers, go ahead, please.
Thank you. This is not scientific, but it's the feeling I get from talking to residents that it feels like we don't enforce the bylaws, so therefore more people are breaking the bylaws. And I'm kind of wondering if there's a way we can get on top of that. For sure, we need at least one more bylaw officer, but I'm wondering if we had a contract for another one for 6 months or a year, and people started realizing, residents started realizing that we do enforce our bylaws, I think we'll get more compliance, and I think actually complaints will go down. So, you know, I think there's just a feeling out there that bylaws isn't going to do anything about it, so if my neighbor's allowed to do this, then I'm going to do this too, and it escalates the number of complaints. So I do think by hiring more bylaw officers, and even on a contract basis, we might see over the short term the number of complaints go down. So I think it's definitely something that we need to strongly address in the budget coming up.
Are there other questions? I had one. I just know that bylaws are sometimes very emotional, that it's not a standard, it's not in a book. And I'm wondering, with one individual knocking on the door, the dog's barking, things escalate sometimes, what kind of relationship do we have with York Regional Police?
To my knowledge, I think we have a very good working relationship with York Regional Police. We do have, I believe, quarterly, if not monthly, meetings with York Regional Police and our parks operations staff to discuss ongoing issues like encampments and other parks-related issues that might warrant their presence or coordinated inspections with bylaw.
Thank you. I just know that you're sometimes alone, and things change very rapidly. It turned out to be something much more concerning to people than what the phone call happened. And I just want to make sure that our staff are well looked after, and I know YRP are called on occasion for bylaw issues. So thank you. Councillor LaHaye, go ahead, please.
Thank you very much through you, Madam Chair. So several of my fellow councillors have made suggestions about ways that it might be improved. I think we need some more data in terms of what the current possible revenue is from the bylaws department, what it's been in the past couple of years. I know it may fluctuate, but before we start making decisions during the budget process on whether we might consider other options or other models of on-call or additional, I think I would be more comfortable if I had some data to support that, and in terms of being helpful during the decision-making process of the budget. What options we might pursue, rather than just jumping to, we need to hire X amount of new bylaws officers. I'd like a little bit more data to base that decision on, please.
I'm not sure if we have that information now, or we'd like to leave it and come back at a different time with more details.
Through you, Madam Mayor, I mean, all revenue that's generated is tracked and would be available as part of the budget review process.
Thank you. Any other questions, comments? Okay, go ahead, please.
Thank you, Madam Mayor. If there's no further questions at the moment regarding bylaws, I'd like to invite our Chief Building Official, Andres Shoney, to speak about the building branch. You'll recall that our Chief Building Official gave an overview as part of council orientation and spoke about the role and the function that the Ontario Building Code has in our municipality. And so again, in keeping with the idea of frequently asked questions, we've tried to zero in on some of the questions that we get most often from either residents or members of council. So over to you, Andres.
Welcome, good to have you with us.
There we are. Good morning, Your Worship and members of council. I'm excited to be here, and I know we could spend a whole day talking about bylaws, but I'm also very excited about buildings. So I would like to move on and hopefully get you some answers to frequent questions. All right, looks like I'm the one behind here. So what is the Ontario Building Code? And this is really coming straight from the Act. The Ontario Building Code promotes public health and safety, fire protection, resource conservation, environmental integrity, structural sufficiency, and accessibility requirements. Its purpose is the promotion of public safety through the application of uniform building standards. So the building code is the same building code throughout the entire province. Next slide, please. What does that actually really mean in the real world context? The building branch is in a unique position where we have to balance and represent various stakeholders. We are in the employ of the municipality, of course, so we do have to represent the municipality, but we also work with the builders, represent their interests. We can't have exorbitant permit fees, for example, because then the builders will be upset. At the same time, we represent the residents of EG, because we are essentially the first line of defense or the first line of quality control to ensure that the houses that people will be moving into are properly built, safe, and enjoyable. As well, the fire department, I'm sure, would appreciate if all the buildings were built properly so that they can fight fires properly. What this means in EG eventually is that we have a stable building stock that people are comfortable to move into and businesses are willing to relocate into. Next slide, please. What is the role of the building branch? It's really the enforcement and the administration of the Building Code Act and the Ontario Building Code. That in itself is very general because there are 40 other applicable laws that we have to respect. Some of these include the Planning Act, such as SPA and zoning requirements, the Development Charges Act, Environmental Protection Act, or LSRCA, MTO, and so on. We also work with professional organizations such as the PEO and the OAA and regulate their professional designers. And we have the Building Bylaw, which Council passed to assist us in enforcing the Building Code Act and the Building Code. Now, there are some exceptions to the Building Code. Only the Crown agencies and Crown corporations do not have to follow the building code, and that includes things like the post office, which is federally regulated, and, for example, the GO station, which is provincially regulated. Now, that being said, they are generally good corporate citizens and still get a building permit with the municipality. However, our enforcement is limited because they are crown corporations. Next slide, please. Some of the additional building branch services that we provide are requests for information. Residents and businesses may ask for septic and site plan drawings. This is usually in support of their building permit application. So if we already have something on file, it saves them money to just reuse something that we have, and they can make their application with it. Building compliance letters. These are generally legal documents that lawyers use in the process of a real estate transaction. And then assistance with FOI requests specific to building permits. We do run a sewage system maintenance program that's required by the Building Code and the Clean Water Act. Our inspectors and our examiners do provide public education. You have to understand that not everyone is well versed in the Building Code, and in circumstances such as that, our inspectors usually are there hand-holding and guiding the homeowner through the construction process. We also provide service delivery enhancements, such as website updates, the CityView portal launch, so that people can apply for building permits online. And I'm happy to say that we have about a 97% uptake on the online portal, which we launched last year. Next slide, please. Funding and structure. We are entirely fee-supported. We are not funded through taxation. The building enforcement reserves are maintained within the town to support the operations. The building reserve currently funds a full complement of 12 staff within the branch, plus 1 development services administrative assistant, half a contract IT, and 2 full-time fire prevention officers in the emergency services. Building reserve also funds CityView upgrades and IT infrastructure that houses our permit administration software. Authority and independence. What are some of the unique features? So, CBOs and inspectors operate independently of you, Municipal Council, when exercising powers and duties related to the Ontario Building Code. The Building Reserve Fund is established to ensure that even if there are no building permits whatsoever, there are sufficient funds to maintain building department services. The Reserve Fund is therefore protected and not available to fund other municipal activities. Under the Act, the Reserve Fund may not be used to offset or exempt fees. Next slide, please. So what is the regulatory framework in someone being able to obtain a building permit? Everything really starts with the province and the provincial policy, and really the next few steps, my colleagues in the planning department will speak to more, but we do have to follow through this. So everything comes from the province. EG has its own town OP and secondary plans, and then we have applicable laws from other jurisdictions, which some I've already mentioned, and only then can we entertain the building permit application and process the documents and eventually issue the building permits. Next slide, please. Duty of care versus standard of care. This is important to mention only because the building code, I used to have a slide up here that showed the building code as 2 4-inch binders, which is really what we have right now. And just to put things in perspective, in the 70s, the East Gwillimbury Building Code consisted of a pocket book that was 20 pages. So we've made quite a bit of progress in the last 70 or so years. Along with that, of course, comes quite a bit of duty of care. And so enforcing the building code is quite time-consuming, and there are a lot of technical requirements. So we do have a standard of care within the building code as well, which parses down some of the projects that we can exempt from the building code, and that is available online. So we often get questions about playgrounds, whether they need a building permit. I can tell you right off the bat that inherently they're not safe. They do have their own standards and requirements, but they're not building code standards. So those are exempt from the building code requirements, just as an example. Next slide. So what do building permit fees cover? Permit coordination, so this is the application intake, the preliminary reviews for completeness, fees, and approvals, liaising between building branch and applicant, designer and other agencies, compiling and sending completed permit packages. I will make a comment here because one of the builders mentioned to us in using the online portal how much time it takes for them to input all the information, and if they really do have to put all that information in to make an application. And so the response is, well, if you don't do it, we're going to have to do it, and it's going to take the same amount of time. So we're finally starting to get some appreciation on the builder side, realizing just how time-consuming it is to process the building permit applications. Once an application is deemed complete, we move on to the plans review. That involves a zoning review and a technical review for architectural, structural, mechanical, and life safety systems. And then finally, when a permit is issued, we have inspection and enforcement. We also look at illegal construction, issue orders, and have court prosecutions. Next slide, please. Do all building permits have the same requirements? Well, the short answer to that is no. We do have a schedule within our bylaw that lays out the different kinds of drawings required for different types of projects. But in short, the building code is broken up into various parts. And I think it's easiest to explain in that one part, being part 9 for residential, is meant for homeowners to be able to apply for a building permit by themselves. So it doesn't require a designer. They don't need an engineer necessarily. They don't need an architect and so on. Once you get into businesses and so on, you start getting engineers and architects being required. The building code also has BCIN, or Building Code Identification Number, qualified designers. That applies to all kinds of designers, including septic designers. Next slide, please. Okay, I get this very often. My site plan is almost approved. Can I get my building permit now? So there are a couple of there's an acronym that I think we're all aware of, and that's SBA. It's a bit misleading because it can stand for two different things. So site plan approval is an SBA, which really is an application that comes before council, and that council approves a development. And that speaks to where the building is going to be and the use of the building, but not how the building is actually going to be constructed. That falls onto the technical side in the building code. Then we have the site plan, and that is, by the way, applicable law. So I cannot issue a building permit without council's approval for a development. The next one is site plan agreement, also SPA. That follows usually the site plan approval. It too is applicable law. There's one important distinction. The contents of the agreement is not applicable law. So what that means is, while you need to have an agreement executed by all the parties, what is in the agreement is not enforceable by the building branch. So I have a case study for you, fresh off the press, really, because we just issued the building permit for the Scholastics building. This would be at the southeast corner of Green Lane and 404. Metris came to us a while back. We've actually completed all the reviews for building code, and it was just sitting, getting ready to be issued. We did not have MTO approvals for the longest time. We did not have site plan agreement executed. So we were just waiting on all the pieces to fall into place so that we can issue a building permit. The Metris one is a bit more complicated above and beyond what we usually have in EG as well, because it involves another municipality. So their address is actually off of Ringwell in Newmarket. So Newmarket also had to sign off on parts of the agreement. So now you have basically two municipalities being party to an agreement. So it complicated things a bit. Again, I could not issue a building, legally, I cannot issue a building permit until that agreement is executed. Next slide, please. Does the building code have any flexibility? The Ontario Building Code is an objective-based building code, which means it has functions and objective statements, so things that you're supposed to accomplish with the construction. Along with that, there are some provisions in the building code that gives discretion to the CBO to evaluate alternative solutions, and that's essentially what it's called, alternative solutions, applications, and approvals. Here are some examples that we've recently gone through. So Woodbine 1, time egress analysis. What that means is basically people did not have enough time to escape from the building in case of a fire. So they had to run tests and calculations to demonstrate, based on the number of people that they expect within the building, how fast they can get out. A mixed glycol water sprinkler system, standpipe system, and then new materials. So Blue Door was building a building with cross-laminated timber, which at the time was not in the building code. My confidence level as a CBO required that I investigate further and ask them to go through an alternative solution. So they needed to provide more information to me to confirm that the objectives of the building code are met. And so once I had that comfort level, I was able to issue the building permit for them. One example I don't have in here, and worth bringing up, because I do care about the residents and the communities as well, barrier-free accessibility. So there's a case I had where the proposed development did not have barrier-free accessible residential units. And I decided to refuse the application because of that. And eventually I had to go to the Building Code Commission, went to ministry, for them to review the case and have them decide whether or not it is acceptable to not have barrier-free access for these residential units. Now, the ministry chose to agree with the applicant, and so those units do not have barrier-free accessible units. But at the same time, I represented the interests of the residents, I represented the interests of the town, and I took it as far as I could. So those are some examples where I have to weigh the interests of everyone and enforce the building code as best as I can. Next slide, please. So when alternative solutions fail, depending on what the dispute is what the topic of the dispute is, if it's expert technical, then it usually goes through the Building Materials Evaluation Commission, or on the federal level for federal approval through the Canadian Construction Materials Center. That was actually recently renamed, so the slide is a bit outdated. And then for all other matters, it would go through the Building Code Commission. The Building Code Commission is really the equivalent of the LPAT under the Planning Act. It is a dispute resolution mechanism. You just don't hear about it too often because it's technical and it's long past the approval process for approving a development. And then if all else fails, an applicant could potentially go to the minister for a minister's ruling. Next slide, please. What is the role of the Building Code Commission? The Building Code Commission represents representation decisions. The CBO is always, almost always the respondent. Decisions are site-specific, but often used as precedent in other jurisdictions. And the decisions of the Building Code Commission are final and cannot be appealed. So with the example of the barrier-free access that I mentioned, there's literally nothing I can do. The Building Code Commission made a decision, that stands, that's what has to happen. Now, I don't want council to think that that's a loss, because the important thing here is to ensure that we will have done our due diligence in the process of enforcing the building code as to the best of our abilities. So when matters go to the Building Code Commission, it is actually a win-win-win situation. Now, let me explain. So a decision in favor of the respondent, which would be the CBO, is an outright clear so-called victory, and the ministry would not have any objections. A decision in favor of the applicant, well, the CBO may have concerns, and the CBO may have refused an application for the right reason. However, the ministry is willing to take that responsibility on behalf of the community to move the project forward. And then in rare cases, there are decisions of no jurisdiction, in which case the decision defaults back to the CBO's discretion. Next slide, please. How is the building code enforced? Talking like this here. I'm actually thrilled to be here again before you, because I take advantage of the educational opportunity I can provide. Public engagement. So we have had a booth at the farmers market. We do communicate with residents. Business cards and written instructions. And then for orders, we have various types of orders at our disposal. Orders to comply, orders not to cover, uncover, orders to remedy unsafe buildings and prohibiting occupancy. These two orders we very rarely use, only because in recognition of the economic importance and the community importance of some of the buildings and uses. So unless things are really unsafe or we really have to prohibit occupancy, we generally don't like to go down this route. Then stop work orders and emergency orders. If all things fail, we do prosecute. Next slide, please. What is the process for prosecution? Very similar to bylaw, actually. It's all about notes, 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 and take more notes, 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 and make sure they're chronological. Obtaining affidavits, filing with the provincial courts and the Superior Court if a restraining order is required, or alternatively known as an injunction. Meeting with regional prosecutor, attending court and trial as a witness for the prosecution. And then finally, we await the decision of the Justice of the Peace. Now, this just takes care of the prosecution. It still doesn't resolve the problem that brought us there in the first place. So just because it went through the court system, it doesn't mean that the building is now code compliant. We still have to follow up with that and ensure that those buildings are upgraded or returned to their original condition. Next slide, please. Roles of the CBO. So what happens when the requirements of the building code are not met? So municipalities this is from a court case with Valence versus Pickering. Municipalities in their position as prosecutors under the Building Code Act do not win or lose cases. They conduct the prosecutions in the public interest to ensure compliance with the Building Code Act. Next slide, please. Does the building code change or evolve? I think it goes without saying it does change and it does evolve. It is an iterative document, but just as a visual representation of what that looks like, this is in Florida. This is a picture from Florida after Hurricane Michael. And what you'll notice is that there is a beach house literally on the beach that was built to the 2020 standards in that jurisdiction. And all around the houses that were built before that date got washed away. So in similar fashion, our building code evolves and hopefully buildings just get better. Next slide, please. Here's another example. This one is from Turkey's earthquake in 2023. Quite a few buildings fell in Turkey during that earthquake. The one that you see standing there is the building for the Association of Professional Engineers and Architects. So I leave it to you to figure out who got a building permit and who did not. Now, I should say that in Turkey they had an interesting arrangement where a developer could pay a fee in exchange for ignoring building code requirements. So that's sort of what happens when you go down that route. Next slide, please. Where can I learn more? You can learn more by coming to me. Feel free to come to my office and I can help you with any questions you have. Or there is the Municipal Councilor's Guide or Citizen's Guide online. Next slide, please. And that opens it up for questions.
Questions? Go ahead, please.
Thank you, through you to Andres. When you mentioned going to the commission to get I guess I look at it as getting guidance, getting that a higher authority. Does that slow the process down? What kind of time does that process take if you have to go to the commission?
Through your worship. It takes a while. However, there's a lot at stake as well. So I'd say it takes anywhere between 3 months to 6 months, depending on how technical it is and how much information the Building Code Commission requires in order to come to their decision. And I can't speak to that because there are appointed members on that commission who would determine what they would actually need to come to a decision. It is a tribunal in a way, so I'm sure they don't want to rush a decision, but yeah, it does take time. The one benefit that does come with a Building Code Commission decision, though, is even though the decision is meant to be site-specific, all CBOs, and I know all designers, still look at those past decisions and try to use it as precedent. So, you know, in the cases that I've taken to the Building Code Commission, it helped us in the future in the consideration of other similar applications.
Thank you. I think that we often hear from applicants that the town is slowing things down. And really what we're trying to do is make sure, as you say, things are being done properly and safely. I wonder is the commission the only tool that allows you to address new building technologies? Because what we're starting to hear about is, you know, as you've referenced in your presentation, there's these new technologies that are coming out that aren't even contemplated by the building code. Is there some element of your judgment, or does it have to go to the commission in order to make sure that it is compliant within the code?
Through your worship. So the answer to that is it depends. Again, there's an alternate solution process which they can take it to a CBO. If the CBO is competent and confident in being able to evaluate an application, then the CBO can make that decision to approve that product or not. The building code is iterative and it does evolve. So there have been some innovative materials that have been put into the building code. So for example, insulated concrete forms or ICFs, they were not in the building code before. They are now in the building code. And then there are other catalysts that force things to be included in the building code. So stage collapses, for example, in Ottawa and around the country, you know, required the creation of an expert panel to determine whether or not we should take care of what's now called demountable structures. So that's been codified as well. So it does evolve. The Building Code Commission essentially, though, is the ultimate decision maker in case of a dispute.
Councillor Hay, go ahead, please.
Thank you very much, through you, Madam Mayor. Thank you for the presentation. It was very helpful. And I have a question with regard to the Building Reserve Fund. So exactly what can that fund be used for? And is it at an adequate place in terms of its balance currently as well as for future purposes?
Through your worship. So the Building Code Enforcement Reserve is meant for the enforcement of the building code, the enforcement and the administration of the building code. And that is true in good times and bad times. So the chief building official's responsibility is partly to ensure that a healthy enough building reserve is built up so that when we do have downtime, we can still keep operating. We can still keep our inspectors and examiners on staff and so on. So our current building reserve is very healthy, and that was intentionally built up to, I think, around 6.5 times OPEX now. I think our treasurer may be able to give better numbers, but I believe it's around 6.5 times our OPEX. And that was really because we were expecting the Upper York Sewage Treatment Plant to be constructed, and that takes about 6 to 7 years. So because we weren't really expecting a whole lot of development for 6-7 years, I had to make sure that we had enough money in the reserves so that we can still operate a building branch. Because, again, the building department is, the best analogy I have is it's a corporation within a holding corporation. So the municipality being the holding company and the building branch being a company within within that holding company. That's the best analogy I have for you. So there's an expectation from the ministry really for us to be able to operate on our own and have sufficient funds to do so.
Madam Mayor, one follow-up question. So,
Yes, go ahead.
Hypothetically, if the town was going to consider hiring additional building enforcement staff or bylaws staff, then potentially they could be, because you've already planned ahead so well, they could potentially be funded by the Code Enforcement and Administrative Reserve Fund. Is that correct?
No, bylaw staff cannot be funded from the building reserve because they are not appointed under the Building Code Act. They're appointed under the Municipal Act. The role of bylaw officers with regards to really only property standards is extremely limited when it comes to building code. So by far, what is in the property standards bylaw is outside of the building code.
Thank you for the clarification.
You're welcome.
Councillor Crone, go ahead, please.
Thank you, Madam Mayor, through you to Mr. Andres. Thank you for the presentation, and I especially want to thank you for mentioning on slide 23 your independence, because I think there are some residents who believe that members of council can bypass your role and that we can overrule it in some way. So I appreciate you drawing attention to that. And I think even with the addition of strong mayor powers, you are immune from that as well. So you've got great job security. I'm impressed. We all should be so lucky. We talked earlier with the bylaws officers on a culture of customer service. Do you think there's, and I know you folks deal with sometimes really hard conversations, and those aren't always easy. What is there more that we can be in your opinion? Is there more, do you think, we could be doing to streamline or smooth over the journey? Because if you're a big builder or a large corporation, you've got a team of people that know the ropes inside and out. It's the smaller guys that are the independent builders and even the small business that are going through this. What could we should always be looking for continuous improvement. Are there other areas that we can look at? I could see Margot Bejan is itching to answer, so I'll shut up.
Go ahead, please.
Thank you. Through you, Madam Mayor. I mean, I'll lead off, and I'm sure Andres can add some additional detail, but I just wanted to sort of back it up a little bit before it gets to buildings. And I think that, you know, it always boils down to communication and effectively being able to articulate what the process is and manage people's expectations around what's involved, whether it be time or expenses or the requirement for professional support. And, you know, that's something that we are working on, so that you know, and that's part of the role that economic development, especially when dealing with ICI or business-related applications, is trying to ensure that we have that consistency and that sort of sales / customer service approach throughout the organization. So, you know, we have been guilty of operating in silos where you get an answer from, let's say, for example, planning that is specific to a planning question, but may not consider the wider environment where you also need to, you know, your journey doesn't end there. There's also, you know, there's a process to go through with buildings, for example, that kind of thing. So we've identified that as something that we really need to work on and make sure that we are not operating in silos, and therefore we're giving a much more global sense to an applicant, especially for someone who is not a developer, who is not experienced in the process. People don't know what they don't know. And so arming them with an understanding that, you know, this is an answer to this question, but there are more questions to be asked is part of it. We're also working on creating some instructional videos that will help people, especially those unfamiliar with the development process, be walked through and understand both the steps that are undertaken and a little bit of the context, the why behind why do you need to talk to the buildings department, or why do you need to confirm that zoning permits the use, those types of things, because it is admittedly complex. And so that is going to be, you know, something we're really focused on for the coming year and beyond, is doing a better job of that initial communication. I don't know, Andres, if you want to add anything?
Yeah, through your worship to Councillor Corn. A couple of things. First of all, with regards to the service, it becomes, and because you brought in bylaw, it's a bit challenging because we do have to have confidentiality, and we do have active investigations going. And in the interest of not complicating our chances of success, it's sometimes best not to provide updates. And to be perfectly honest, we're not obligated to provide updates to the complainant. You know, if someone complains to the YRP about an assault or whatnot, the person that complains doesn't get updated. We're investigating. That's usually the kind of answer that they're going to get. And, you know, it may take a year, whatever, but, you know, you kind of have to leave it to that enforcement body to investigate. With regards to other assistance, I think it's important to note that the building branch is a regulatory branch. So we're regulators. We are first and foremost regulating the Building Code Act, enforcing the Building Code Act. We are not actually designers. We are not educators, technically. However, in the interest of making our lives easier, we do assist. So that's why we do have DRCs, and we give some initial pointers as to what potential obstacles someone may run into and how to resolve them. But we can't actually design a building or find a solution for them. So that's something that really the owner and the owner's team of designers needs to figure out. And unfortunately, there isn't a whole lot more we can do on our end. We've tried to reach out as often as possible. Our inspectors, when they're out on site and someone's building a deck, they'll give them pointers how to put, you know, a nail into a piece of wood. Because some people have never lifted a hammer in their life, but they decided to undertake building a deck. So, yeah, there's an education component to it, and we try to help, but we are first and foremost regulators.
Are there other questions or comments? Thank you. I'm going to recommend that we have a 15-minute break. Could I have a mover and a seconder for that, please? Councillor LaHaye, Councillor Roy DiClemente. All those in favor? And that's carried. Thank you very much.
Okay, welcome back. Again, as Mayor Haxon had previously indicated, she has had to step away, and I have assumed the chair for the remainder of our meeting today. I've also been advised that Councillor Johns has had to step away, so Madam Clerk has advised me that he's absent with notice. I will note that we were supposed to go until about noon, so we're a little bit over schedule, so I appreciate members of council who have made the time today to be here, and I'll turn the microphone over to you, Mr. Kubnik, to do the final section of our workshop today. Thank you.
Wonderful. Thank you very much. And, earlier we heard about bylaw and buildings. Now we're going to move on to the planning branch and what we do. And I know at the beginning, Margot began our presentation with the organizational chart. I'll get into the planning branch a little bit here and just show you a little bit about who we are. Today, myself and Victoria will be up before members of council giving this presentation. We also have a senior planner on our team, Matthew Dowd. We also have Janeti Nagulan, who's our planner 2. Our planner is Nicole Schroeder, and Pardis Sanjanchi is our planner and secretary treasurer for the Committee of Adjustment. Now, what's the role of municipal planner? Now, we work with a lot of members with council, and you guys attend our meetings as well. You may be aware that we develop land use plans in our communities, and we take the direction of the province. In this case, I've outlined the Planning Act. There's other provincial plans that that the Planning Act and other acts allow to exist. And so we base our official plan and our secondary plans based on these legislative documents. And we recommend policies for managing the town's land uses. That could be both urban and rural, and we process our applications and by the administration of these tools in our official plan and our zoning bylaw. And these documents, oftentimes in this circumstance, for instance, in our official plan, our existing one, I believe, is a time frame of 2031. We have a new one which was adopted by council and will be before you once again, and I'll let Victoria Moore go into that. Baldessera. Apologies, I should have wrote that. And okay, so I'll get that right one day, Victoria. There's a long range of objectives there to the year of 2051, right? So it's forward thinking, it's outward looking. In terms of the Ontario's land use planning framework, again, we have the provincial statutes, such as the Planning Act, Ontario Heritage Act. There's other things such as the Greenbelt Act and Oak Ridges Moraine Act. From those policies, statutes, we're able to develop provincial policies, such as those outlined in this slide. And then we have our official plans, which conform to those provincial policies and enable land use control, such as those mentioned here, like subdivision bylaw, zoning bylaw, or site plan control for applicants to come in and advocate on their behalf for their land rights. The ones I've outlined in red there, following those, as Andres has outlined as well, then you can go forward with a building permit. It's not till those other things are worked through that you can then move on to that stage with a stage for the building permit. I've outlined in red those which have the potential for an OLT appeal, and also many of those as well will be before council, in which council can also have a voice in those planning instruments. In terms of how the development process works, it begins with pre-consultation. We have a process called development design review consultation, and so we call it a DRC. And that's essentially where we have an applicant come in to show us kind of on a high level, kind of conceptual basis, what they're thinking of doing on their land. We provide feedback to the applicant. We have a number of staff members and agencies that participate in that process to provide the feedback the applicant requires to make a good and fulsome application, what we call a complete application, to the town. When we receive that application, the official application, we do circulate it to our staff commenting partners and agencies. They review it, but they also come back to us saying, hey, there is, we have everything we need, or maybe there is something that has been missed in this application. So we would either deem the application complete or incomplete based on that information we receive from the applicant. We make every effort in the development review consultation, in the pre-consultation, to give the applicant all the things they require through a checklist and comments so that they do make a complete application to us. In terms of, we also come, once we have an application as well and it is circulated, we do come before council through a memo, and I think members of council have seen this on a number of occasions. And we also have a public meeting, which we explain what the application is about and have the applicant and perhaps staff discuss the application a little bit and what it is trying to do. Ultimately, after a number of circulations, because there's a lot of back and forth to kind of address staff comments, staff concerns, public comments, public concerns, members of council concerns. There is a recommendation report that finally comes back to council. It's a recommendation report made by members of staff recommending a course of action for council, and council decides to choose that course of action or not. So council decides on that application. In the background, there's also agreements often being assembled on these things, whether they are site plan approvals or whether they're draft plans of subdivision. And oftentimes, again, in these planning instruments, applicants have a right to appeal based on council's non-decision or perhaps disputing the decision of council. And we won't get into the details of it today too, but some of those some of those rights of appeal have recently altered within this year. So the Ministry of Municipal Affairs and Housing has narrowed the window of who can appeal an application.
Mr. Krebnick, could you just pause for a moment? We do have a question.
Thanks.
Go ahead.
Yes. I know there's a lot of slides, so I don't want to get lost here. It says if delegated. Can we just talk briefly about when it's delegated to staff and when it is council's decision?
Sure.
The rules have changed.
There are certain things that are delegated and not in terms of planning act applications. Site plan control is something that is delegated to staff. So staff now reviews and makes a decision on a site plan application. Other instruments such as draft plan of subdivision or official plan amendment or zoning bylaw amendment will come before council. So that's kind of, I guess, the if delegated or not portion of it. So you'll be quite far along the process once you get the site plan, if you do have to come in and have an official plan amendment and a zoning bylaw amendment. So members of council will be quite not only familiar with the application, but its kind of form and look, its feel, before it gets down to that point.
I think we should clarify that delegated approval was not council's choice. It was delegated by the province to staff.
Yes. Thank you for that clarification, Madam Chair.
Thank you. Go ahead.
And how are our applications processed? So I actually, in this case, in a way, I will start off with this last bullet to say that, when we do receive an application or we do know of an application forthcoming, we do review it against provincial policies, against official plans, the regional official plan and our town official plan, as well as the zoning bylaw amendment to determine where it needs to be in the process, what application needs to be made, and what application needs to be made. Apologies, and then it kind of scopes the application for us and gives us a better understanding of the timing this application might need to and who might need to get involved in the application. Next slide, please. So if a project doesn't conform to the official plan or zoning bylaw, the Ontario Planning Act foresees that I think there is a potential for applicants to make an application on their own behalf and on their parcel of land because official plans and zoning bylaws certainly give very clear direction to applicants, but at the same time they are not static in the sense that there is a right of an applicant to request an amendment to a zoning bylaw or to an official plan. So, and through that amendment process, they're making a case for their land or for their holdings and how how their proposal conforms to provincial policies and to the provincial and is consistent with the provincial policy statement. So, it may be something that our official plan or our zoning bylaw did not necessarily foresee, but there is perhaps a valid rationale behind their application to move forward in the direction they're requesting. And sometimes there's requests for new uses or zoning standards that have maybe not historically been a part of that part of the town, but it is something that's seen as a positive and is meets the intent of compatibility and perhaps is desirable to members of council and community. So again, in these cases, the official plan amendment or zoning bylaw amendment are tools used by applicants. Next slide, please. Now, when I talked about official plan amendment or zoning bylaw amendment, those are larger and more time-consuming applications, more costly applications that require more studies, more reports. If a resident in the town of East Gwillimbury would like to have something small done on a local, or not a local, but on a lot basis for their own home, there's a minor variance, which is, apologies, would be a minor change. They go through something called a minor variance. So now a minor variance has to consider what we call 4 tests. So is the application minor in nature? So these are items that the Committee of Adjustment will review when they're looking at an application for a minor variance. Is it desirable and appropriate development or use of the land, buildings or structures? Is it in keeping with the general intent of the official plan or with the general intent of the zoning bylaw? So if the request is minor, it goes through that avenue, the Committee of Adjustment, and the committee is an appointed body which makes that determination on that minor variance application. Next slide, please. So, and just from a high level here, it'll again show you, so if it's a larger application, like an official plan amendment or zoning bylaw amendment, council is the decision authority and will make a decision. Certainly, it will be supported by a recommendation by staff, but council is the decision authority. And if it's a minor variance, the Committee of Adjustment is the decision authority. So at this point, I believe I'm going to turn over the presentation to Victoria Baldessera.
Before we do that, I will compliment you on having not used the town of Erin in your, you often get mistaken when you say it. So you did EG, but now you got to work on Baldessera. But before we turn it over to Ms. Baldessera, I think Councillor Leahy has a couple of
And
questions.
through you, Madam Chair, that's only in small, intimate settings, never in public venues such as this.
Very true. Go ahead, Councillor Leahy.
Thank you very much, through you, Madam Chair. My question is with regard to the application process and the software that's being used in terms of how well is it working and what is the feedback that you get in terms of doing all of that online? And is there room for any improvement in the process?
Yeah, and so through you, Madam Chair, we are presently on the planning side, in the planning branch. We're not presently on CityView, which is utilized by the building branch, but Information Technology Group is assisting us to place our Committee of Adjustment applications as a trial within CityView, and we hope to then, if that works out, expand that to the planning applications. Now, that has taken a little bit of time presently. We wanted to start that initiative a little bit sooner. It requires some outside or outsourcing of training to place CityView or place some of that planning function, that Committee of Adjustment within CityView. My understanding is though that's rolling along and that will be in place soon. So once we do that, we will test run it through the Committee of Adjustment applications and see how that works. I suspect we would need a good few months to perhaps half a year to see how that's effectively working for us in Committee of Adjustment before we make a decision to roll it out to the rest of the planning applications.
And a follow-up question, please. And what is the standard amongst other municipalities in terms of learning best practices and having a smooth process? At the AMO conference, the Association of Municipalities of Ontario conference, there were actually multiple vendors there who were promoting permits and other types of planning applications with their particular software as being cutting edge and as being improving the whole process for the applicant.
Yeah. Through you, Madam Chair, certainly, you know, Town of Erin uses city.
It just happened.
Oh, now this is, you've jinxed me. Okay. So presently, the East Gwillimbury uses a city view. Other places use things like Cloud Permit, or there's other software. Certainly, they all purport to be the best at what they do. It is a rather large initiative to kind of, you know, change over to a different type of software and to, you know, back up all the work you have into that. So I don't think we have our intention is to move forward with CityView as it intends to be, or it appears to be working well for our building branch and their operations. And oftentimes, I will say that some work better within buildings than planning because of notice requirements, because of just the standards and processes within each application. There are strengths and weaknesses of all of these, of each software. But I think now that the town of East Gwillimbury has CityView, you know, that's something that, at least in my mind, I'm intent to really roll out to the rest of the planning branch and hopefully move in that direction.
Thank you. I think maybe another staff member wanted to help answer too. I appreciate the context and the background. I'm looking for ways that we can be as efficient as possible. So I appreciate the feedback.
Certainly, our investment in CityView was a significant one, and we've also been fortunate in putting even just the building permits online. That was perhaps a way of putting it is a silver lining that came out of the pandemic, because we were forced to get creative in how we manage that. Ms. Gandhi, I think you had indicated you wanted to add to the discussion here today. Go
Just
ahead.
as a follow-up, as part of the 2025 business plan, the Corporate Services Department indicated that we are going to be developing an IT strategy. And that is intentional so that we can look at all of the needs for the organization and identify priorities so that we can put concentrated energy into those areas where there is an increase in demand or that there is new technology that we could explore. And that's going to be done, the strategy will be done collaboratively with council and with staff. So that's something to look forward to.
Thank you. Okay, so I think we're going to move on to Ms. Baldessara's portion of the presentation.
Thank you.
Thank you, and through you, Madam Chair. So I'll give a bit of a brief overview on the status of the official plan. We provided an update to Council earlier this year in the spring, as well as we made a presentation to the development community, and we posted the official plan modifications on the town's website. So town planning staff have finished making the modifications to the adopted official plan as required by York Region, who was our approval authority at the time that the plan was adopted. Since meeting with members of council, we've taken some of that feedback and we've made some additional modifications to the plan. However, as of July 1st, 2024, the Ministry of Municipal Affairs and Housing became our new approval authority. So York Region is no longer going to be the body approving our official plan. And as a result of that change, there's some new requirements from the ministry that we have to address before we can bring the OP back to council for readoption. So there's some additional modifications that need to be made to address the new provincial planning statement, which I'll get into a bit later, and we're working through those changes currently. There's also some additional public consultation requirements, including additional Indigenous consultation beyond what was done through the original consultation with the formation of the official plan. So we will complete that once the modifications are made. And then there's also some additional notice requirements to provide the ministry with 90 days notice in advance of adopting the plan to allow them to begin their review. Next slide, please. So in terms of next steps, as I said, planning staff are currently working to address the new requirements from the ministry, including modifications to include new policies from the PPS. So once that's complete, we'll carry out some additional public consultation, including Indigenous consultation, and we anticipate that a proposed modified official plan will be presented to Council before the end of this year. And then we will forward that modified OP to the ministry to begin their review and hopefully get the final official plan presented to council as a clean version for readoption in the first quarter of 2025. Next slide, please. So following the official plan adoption, a municipality, once adopting a new official plan, is required to update the zoning bylaw to conform with any new policies that are made through that official plan. So I know we've been talking since our 2018 bylaw was adopted in 2020. We've kind of been talking about this housekeeping update to address some inconsistencies and some issues that have arisen as a result of implementing that zoning bylaw that we didn't foresee before adoption. However, once the new OP is adopted in 2025, we will proceed with updating the zoning bylaw in its entirety. So that will include addressing new provincial legislation, including the PPS. So for example, some policies around permitting accessory dwelling units in accordance with some of the changes that have been made recently to the Planning Act. And we will also do that administrative housekeeping update to address some of those administrative changes that have been identified since the original bylaw was adopted in 2020. And then we're also looking at exploring improvements to some existing provisions to address some kind of common zoning issues or interpretation questions moving forward. So things like driveway widenings, setbacks related to kennels, and things like that will be explored. So that will be a public process requiring public consultation, and any updates made to the zoning bylaw will be approved by council. Next slide, please. So some of the most frequent questions that we're being asked about lately is all of the changes to the provincial legislation. So I know we've presented a couple updates to council previously on changes under Bill 109, Bill 23, and since then there have been a number of other legislative changes. So I'll get into those in the next few slides. So the first big change, which I alluded to previously, is that York Region is now an upper tier municipality without planning responsibilities. So what that means is they're no longer the approval authority for the lower tier municipalities to approve official plans and official plan amendments. So as a result, the Ministry of Municipal Affairs and Housing is the new approval authority for the East Gwillimbury official plan. And the town, rather than the region, is the final approval authority for most official plan amendments. So that would be site-specific applications. Another major legislative change is the new provincial planning statement. So I'll go over some of the key changes to that in a future slide. But of note, the new provincial planning statement, or PPS, comes into effect in October of this year. So that replaces the former provincial policy statement and the growth plan for the Greater Golden Horseshoe, and kind of includes policies from both of those previous plans into one document. A third major change is the deadline to review and designate significant heritage properties that we have previously reported to council on. The original deadline was January 1st, 2025, and that has been extended to January 1st, 2027. So that's a significant change for us. It will allow us to kind of take time to develop our comprehensive heritage strategy, work through the Sharon Heritage Conservation District, and a few other heritage matters. The next change is that the requirements for application fee refunds has been repealed. So previous legislation under Bill 109 required the town to refund fees where certain deadlines for review and approval were not met. So while there's still statutory appeal timelines, so applications can be appealed to the OLT if not processed and approved within the specified timelines, we're no longer required to refund application fees. So that's an important change for us because it allows us to sort of take time to ensure that applications are reviewed properly. There's also been new use it or lose it policies. So those policies are meant to address stalled developments where there's been historic approvals, moving forward, if there's an approval that doesn't proceed in a timely manner, it gives the municipality some ability to reverse some of those approvals related to things like servicing allocation. The final big change that I want to note is that the responsibility for natural heritage review has shifted from the LSRCA to the town. So since we don't have in-house ecologists specializing in natural heritage at the town, we will be issuing an RFP in the upcoming months to retain a consultant that would work to provide natural heritage reviews on behalf of the town. So that will be a similar peer review process to what other departments within the municipality use for reviewing certain development applications. And those reviews would be paid by the applicant sort of in lieu of the fees that they would have paid to the LSRCA previously. Next slide, please. So now we'll go over some of the changes under the new provincial planning statement. So first big change is that it identifies 29 large and fast-growing municipalities in Ontario and sets out a number of specific policies related to growth for those municipalities. However, East Gwillimbury is not one of the listed 29 municipalities, so those policies do not apply in East Gwillimbury. There's also a change that now the population and employment growth forecasts are based on projections published by the Ministry of Finance. Previously, those projections came from York Region. So the new PPS also reintroduces some minimum targets for the provision of housing that is affordable to low and moderate income households. So there were some amended definitions in the new PPS, the first one being for affordable housing, which narrows in the focus of affordability to within the municipality, whereas previously the definition was region-wide. And there's also an amended definition of housing options that specifically lists certain housing forms such as rooming houses, laneway housing, garden suites as being options for affordable housing that weren't previously listed. So the new PPS also now requires rather than encourages planning authorities to set minimum targets for intensification and redevelopment. So this is one of the significant policies that will be addressed in our ongoing review of the modified official plan. Next slide, please. So the new PPS removes and replaces the concept of healthy, livable, and safe communities with complete communities and provides a new definition for complete community, which I won't read, but it is on the slide. So there's many new policies under the PPS that have a specific focus around giving planning authorities the ability to work towards achieving what is defined as a complete community. So things like ensuring walkability, access to transit, and that both residential and non-residential uses are in proximity to create that complete community objective. Next slide, please. So another significant change is that municipal comprehensive reviews are no longer required to facilitate settlement boundary expansions. So there's a list of criteria in the PPS that must be considered when considering a settlement boundary expansion. And notably in the context of East Gwillimbury, that would mean that settlement area boundaries expansions cannot include lands in the Greenbelt or the Oak Ridges Moraine. So we are really limited to the existing White Belt areas for any future expansions. And then there's also some new employment policies in the PPS. So the first significant one being for addressing land use compatibility between employment areas and adjacent non-employment or sensitive land uses. So that puts the onus kind of on any new developments, both employment and non-employment, to ensure that adequate transitions are in place. Next slide, please. So another new employment policy prohibits retail and office uses as standalone uses in employment areas where they are not associated with the main employment use. And then the policies also prohibit residential, commercial, and institutional uses in employment areas. So really focusing on employment areas being solely employment uses with only minimal ancillary uses that are seen as compatible. And then the final employment policy that I wanted to address is that planning authorities, so municipality, may now remove lands from employment areas without the need for a municipal comprehensive review. So there is quite a detailed list of criteria that need to be met in order for a municipality to consider an employment conversion. Next slide, please. So I'll now get into another frequently asked question, which is around the Oak Ridges Moraine and why development is restricted or in many cases not permitted in the Oak Ridges Moraine. So just to highlight that the Oak Ridges Moraine is an environmentally sensitive geologic landform, and the intent of the Oak Ridges Moraine Conservation Plan is really to protect and wherever possible improve or restore the ecological and hydrological function of the Oak Ridges Moraine. So within the Oak Ridges Moraine Conservation Plan, there's 4 different types of land use designations, and those filter down into our local policies as well. So I'll go over those briefly so that everyone understands the difference. So the first is natural core areas. So these are the areas with the greatest concentration of key natural heritage features that are seen as critical to maintaining the integrity of the Oak Ridges Moraine as a whole. So this land use designation is really the most restrictive, and it only permits existing uses and the most low-intensity uses. Within the natural core areas, which do make up a significant amount of land use designation within East Gwillimbury, things like new agricultural uses aren't permitted because they're seen as negatively impacting the ecological integrity. So next we have the natural linkage areas, and these are sort of treated almost like natural core areas as they protect the critical linkages between natural core areas within the Oak Ridges Moraine area. And they're usually located along rivers and streams, but that's not always the case. And these areas are vital for maintaining ecological and hydrological connections that support the Oak Ridges Moraine. Up next, we have the countryside areas. So these are essentially agricultural lands and transition areas to natural core areas. So we don't have too much of our Oak Ridges Moraine area that falls within the countryside designation, although there are some. But uses in this area are intended to support agriculture and again, not negatively impact any natural core areas. And then finally is the settlement areas. So these reflect existing settlement areas that predated the Oak Ridges Moraine Plan. So within East Gwillimbury, we have 2 Oak Ridges Moraine settlement areas, one being part of Mount Albert and the other is the community of Holt. So our local official plan and zoning policies were developed specifically to implement the policies of the Oak Ridges Moraine, which is why often when we're asked if an amendment to the official plan would be considered, the answer is no, because those changes do not uphold the land use designations and policies of the Oak Ridges Moraine Plan. Next slide, please. So on a similar note, we often get questions about the Greenbelt Plan, which is different from the Oak Ridges Moraine. But the Greenbelt Plan essentially establishes where urbanization should and should not occur, with the overarching goal of protecting Ontario's agricultural land base and natural heritage features. So all land use decisions within lands within the Greenbelt Plan must conform to the policies of that plan. So again, while less restrictive than the Oak Ridges Moraine, our policies are really in place to implement the policies of the Greenbelt Plan. And they do permit some uses, such as agricultural-related uses and on-farm diversified uses, but only in cases where the proposed uses or proposed development supports the agricultural economy or the policies of the Greenbelt Plan. And with that, I will turn it back over to Jack.
And thank you, Victoria. And through you, Madam Chair, maybe I'll ask if members of council have any questions of Victoria's portion of the presentation, or we can hold them till the end.
Go ahead, Councillor Crum.
Thank you, Madam Chair. This may be a question that comes up in trivia night, but correct me if I'm wrong, we passed, as a council, we passed our official plan in 2022, or thereabouts.
Yeah.
We should have it all signed and sealed by next year, 2025, correct?
That's
So
correct.
my understanding is every 10 years, we review it. So do we review it from the date we finally approve it, which is 2025, or will it be from 10 years hence, from 2022? As I said, it might be a trivia question.
Yeah, and it would be 10 years from the date of adoption, but obviously there is some flexibility within that 10-year time frame. There may be reasons why it needs to be reviewed sooner. I know our last official plan was 2010, and we got it started actually, I believe, in 2019. So there is a little bit of flexibility there.
Okay, thank you. And I do appreciate, if I may, Madam Chair, one more, that I appreciate the shout out on the Greenbelt and the severances. I know I have many residents in our, in Ward 3 that are on the Greenbelt who would dearly love to sever their properties to give an acre or two to a kid or whatever. But it's the provincial legislation that stops them from it, not us. It's the provincial legislation that we have to adhere to. So I appreciate the shout out on that. Thank you, Madam Chair. That's all.
Thank you. Okay, let's keep going then.
Thank you. So now we're on a slide about sanitary servicing allocation. And I believe members of council have seen this slide from York Region previously. And just wanted to come back to it to really illustrate the timing of and the phasing of future servicing allocation and when we expect to have some of this infrastructure in place. So phase one and some of the background work with that is underway. That I believe is fully funded through development charges, but phase two and phase three, funding's somewhat up in the air and unknown presently in terms of a funding source. And so some portion of that will come from the development community. So those kind of discussions and negotiations will be underway in the near future. Phase one also will be impacting Aurora, Newmarket, East Gwillimbury, and King. And I believe the most recent estimates is should accommodate 25,000 persons divided amongst those four municipalities. So, and I don't have a unit number in front of me. Those units will differ according to what type of unit it might be, whether it's single detached or townhouse. But that's the direction presently. Next slide, please. And so will EG achieve its housing targets? So, the potential for us to help EG achieve its potential housing target is through our planning approvals. So I will say that EG has committed, I believe last year in 2023, to commit 4,300 units within EG by the year 2031. So, and I will say that staff have processed applications and provided approvals and allocation for more than 3,000 units. So the main thrust of it, or the bulk of it, is in place in terms of approvals and allocation. We do rely heavily on our development partners then to execute on those approvals. So we will do our best to continue to bring that number up to that 4,300 and beyond if need be. And that's the work and that's the side of things that we're involved in, right? It's the policies, it's the approvals of those units, and we will have to see that they are executed upon. So in terms of affordable housing, the town's role in this, so a lot of this, bulk of this affordable housing goes to York Region. Housing York Inc. offers market and subsidized housing to residents in York Region. We as staff do have a seat on the York Region Municipal Housing Working Group, which comments into this process and is made aware of developments within York Region. We also provide updates to our official plan and our zoning bylaw to allow to speak for affordable housing and to allow more varied types of housing. And that's some of the important part of offering varied types of housing in our new developing communities or the complete communities. We can also use our town allocation policy to direct future reserve allocation to affordable housing. We attend industry events, such as one coming up in October, a MO symposium on supportive housing, to learn about affordable housing and how we can help resolve or help bring resolutions to affordable housing or offering affordable housing. And in the future, council can also choose to focus town resources in funding to affordable housing initiatives. Oftentimes, it's the larger municipalities and the regions and counties which take the lead because of funding and the resources they have. So, those resources are somewhat minimized at the town level, but there's always efforts that we can all make to bring this into a reality. Oh, apologies, next slide. And a little bit of update on the Thinking Green development standards for the town of East Gwillimbury. Early this year, myself and a colleague have met with a number of municipalities to learn about their green standards, their initiatives related to green standards, existing ones and ones that are forthcoming. We also struck up a partnership with the Clean Air Partnership and with regards to leading workshops in the town of East Gwillimbury, and those workshops involved members of staff, members of senior management, and they have reported on each of those meetings, and those meetings were really, and those workshops were really to gather information about our existing standards, how they are being, the quality of those existing standards, and also how they're being utilized and enforced in our municipality. So the final report essentially will be pointing to us going forward in 2025 with going out and getting a new set of tiered standards for East Gwillimbury. So that will be our objective for 2025. Bringing forward new green standards for the town of East Gwillimbury. So the previous iteration was from 2018, so this is quite an update in 2025. So 7 years is a long time when it comes to green standards and what they are and their objectives. So it's time for that update, and it's well overdue. And we hope by the end of next year to have a new set of green standards and a user guide in place, and to have training underway for staff to make those more in the forefront of the development review process. And that's the last slide for council today.
Thank you very much. I know Councillor Carruthers has indicated that she has a question. I'm assuming she's got two now because we talked about Thinking Green development standards. Go ahead.
Thank you. Can you pull up that last slide on the Thinking Green development standards? My question is around how council has our input into this. I'm seeing a lot, this one, right. I'm seeing a lot of different workshops. Are any of these with council, or do we just find out about it when it's all done on December 2025?
Thank you, Councillor, for that question. Through you, Madam Chair. So the bulk of council's work on this initiative will be in this kind of next upcoming phase in 2025 on the creation of our new standards. So I guess the professionals within our organization have been able to communicate to us pertinent information on the quality of the standards. And also our consultant has been able to do research and communicate to us what others are doing out there in other municipalities. So we know where we're kind of falling short on these standards. We know they have to be revised. It's essentially at the next point in our phasing and our strategy, and the main bulk of it will be the creation of these new standards. That's where we hope to engage council and members of the public.
So at what point in this chart is there a touch base with council and get their input? Is it in the workshop, or is it in August with the draft report? I know Ms. Gandhi also indicated that she wanted to speak, so maybe she can be your phone a friend.
So through you, Madam Chair. Council will note that the Thinking Green Development Standards, as much as it is absolutely part of this conversation, it is equally part of our council-approved environmental strategy. And so we are currently working with the consultants to sort of do an assessment of where we are. Once that assessment, that gap analysis is conducted, then there's an opportunity to identify what the art of the possible is. And that is certainly when council is going to be engaged, the development community is going to be engaged, and this is all happening through 2025. So in terms of timelines, council can expect to be engaged in the Thinking Green Development Standards process at that point, along with the development community.
Does that cover it for you, Councillor Crothers?
Thank you. Yes, I noticed the absence of getting council's input early in the process when this chart goes up there, and I think it's very important that council have input early in the process before we start talking to other areas, because I think that it might inform some of the questions that we're asking of other municipalities. So my second question was back around, we're talking about housing targets. If we can go back to that slide, I don't think it really addressed whether or not we will be meeting the housing target, what the housing target is, how close we are to meeting it. It says potential, but I don't know what are we talking about? How many are we short?
Through you, Madam Chair.
Yeah.
So, our housing target is 4,300 units by 2031. So we do rely on development partners to make those applications. So certainly, it's difficult to foresee or foreshadow what's coming down the pipeline. But we do have an indication through some of the servicing work that's happening through East Gwillimbury, through York Region, because we also rely on York Region as our partners to develop the infrastructure. So we know where the phasing of that servicing will be coming online and how many units that can deliver us. So if we are, in this case, we have 3,000 approved and allocated. We need 4,300. And we know in phase one, up to the year 2028, there will be 25,000 persons provided for through phase one servicing work through York Region. So we'll be, I think, well ahead of this target by 2031.
Sorry, my question was about this year. So we didn't make our housing targets last year. I'm wondering what the target is for this year and how close are we to that target for this year?
Sorry, I see Margot's hand. Maybe I'll let her address
Ms.
this.
Bégin would like to contribute.
Through you, Madam Chair, I'd have to go back and check the target for this year, but I believe it was somewhere in the range of 450. We will not, I can confirm that we will not make our, the annual target that was assigned by the province. I think that the key takeaway here is that we have absolutely, as a municipality, done everything we can to get us to the point where homes can be built, and then at some point it falls to the builders and the development community, and we recognize that they are very much impacted by market forces. So no, we will not make our target for this year, but is there anything else we can do to achieve our target? I would say no, we've done it.
Thank you. That summarized it quite well. My final comment just is around affordable housing. And when we talk about affordable housing, we need to think about car dependency as a factor in affordability. It's the cost of the land to park the car. It's the cost of the car, the insurance, the maintenance, all that kind of thing. So when we're talking about affordable housing, let's make sure that we're also looking at car dependency so that, I keep talking about the need to have shops and services within 800 meters according to our old current Thinking Green strategies. So that becomes an affordability issue as well as an environmental issue. Thank you.
Just while we're talking about the housing target, I see your hand, Councillor Leahy. I think it's really important for us as a municipality to communicate with the public and with the province and with anyone else who wants to listen that we've done our part. And in fact, we've more than done our part because with 7 years to go, we have put approvals in place for the ability for us to meet 70% of our overall housing target. And so what that does is it means that for the next 7 years, we only have to do 200 approvals. We know that in phase one of the service, our big challenge is the infrastructure. We know that in phase one of the servicing allocation challenges, there's going to be 25,000 more people. And these are 4,300 housing units. They are not 4,300 single detached dwellings. So if we build condos, if we build purpose-built rental, if we build laneway housing, or we build garden suites, we're still meeting those targets. So I think it is really important for us to trumpet the fact that when we talk about our housing targets, we've done our part, and it's now up to the development community and, quite frankly, the housing market to respond accordingly. And so I think it makes sense for us to issue a press release or to put out a report or put out a public statement to say, we're doing our part. There's other market forces at play here. So I'll leave that. It's just a plea to say, hey, we're doing our bit. And then Councillor Leahy, I think you had a question. Please go ahead.
Yes, I do. Thank you very much, through you, Madam Chair. And it relates directly to this, because on Friday the 13th in the morning at the York Region offices, the Mayor and I attended an announcement of $139 million in the first phase, investing in the first phase of the York-Durham sewage solution. And it was stated that this is paving the way for up to 8,000 homes to be built in Newmarket, Aurora, and East Gwillimbury. Now, as far as I'm aware, Newmarket's pretty much built up, and East Gwillimbury has more potential for building. So I know that this presentation was prepared before today, probably before Friday even potentially, but how does that announcement positively impact the escalation and the acceleration of building more homes in more housing units in East Gwillimbury with that investment from the province? Thank you.
I think Ms. Bégin wanted to answer, but I think it's probably best if we bring up slide 59, which shows the proposed projects and phasing. Yeah. And we're seeing the phase one is costing $500 million. So I think that $139 million might be part of that, but please go ahead.
Thank you, through you, Madam Chair. Yes, so we weren't able, I think we shared in closed session, we'd updated council that we were applying for that funding jointly with Aurora, Newmarket, and the region. So it's great that it has now been, the announcement's now been made public. This was an infrastructure stream that we applied for with, and what it did require some of the other municipalities to set aside some of the projects that they were going to seek funding for to be able to take this collaborative approach. It's likely going to impact phase one of this expansion most directly. So just from a budgetary standpoint, if it takes some budgetary pressures off of phase one, then ostensibly those funds can be moved forward to support phases 2 and 3, which are as yet unfunded. So so kind of big picture, it helps put the infrastructure in the ground that needs to happen to support the expansion of those additional 8,000 homes. We do not yet have a breakdown on what the distribution will be. To your point, obviously it has to fit where there's room for expansion, but that's still being looked at. at the region and with our other partners to determine how, like, what the dispersion of those 8,000 homes will be. But I think it's important to note too that those are above and beyond what we've already identified within, you know, the 3,000, to use that sort of ballpark figure of what already has approval and what already has allocation. Those theoretically could be built tomorrow if the market would support it. These additional 8,000 homes, or the potential for the 8,000 homes, is a longer term project, but we'll have the ability to contribute to our ability to meet the housing target in 2030, by 2031 for sure.
Yes, and one follow-up question, if I may, through you, Madam Chair. And so on a previous slide, it was stated that we were not listed as one of the 29 communities that were on the growing list. And so I'm a little bit confused about how we can be the fastest growing municipality according to earlier statistics, and that we're receiving this additional investment for the first phase of the York-Durham sewage solution. But what list was this that stated that we weren't one of the 29 communities on that?
I can't speak to the rationale for how the province derived that, through you, Madam Chair, sorry, through that list. I'm not sure. I mean, where it matters, I guess, or impacts us is how the policy applies. It doesn't have any bearing on the expansion, the YDSS North Expansion Project, nor would I expect it to have any bearing on future funding applications such as the one that we applied for under the Housing Enabling funding stream that we were successful in getting the 139 million through. So I think they're kind of separate issues, and I don't actually have, we can look into it further, but I really don't have any insight into the rationale for packaging it the way that they did.
I guess it really comes down to census data versus provincial lists. I think they're mutually exclusive. Any other questions from members of council? For one further, Councillor Leahy?
Yes, it's with regard to one of the slides where you noted that town staff sit on the York Region Municipal Housing Working Group. I wanted to just follow up with that because I was really inspired and energized when I came back from the AMO conference, and I thought we need to start a committee here in East Gwillimbury to talk about how we can build affordable housing and all of the components of that. And so we already are seated on York Region Municipal Housing Working Group. So my question is, when did it meet last? How often does it meet? And what is the communication between town staff who are sitting on that group and with council members so that we can get updates and information about what's being discussed and what things are taking place on this working group? Thank you.
Thank you. I think we're in that format where staff tell us how things are going, but if you have further details to share.
Through you, Madam Chair. So I have been a part of that since my arrival in East Gwillimbury. I believe to date I attended a couple of meetings of that committee. They're supposed to happen on some regular basis. I believe it is quarterly, but I think the last one has been several months away, or was several months ago, because sometimes it relies on, the York Region's going through a strategy right now, presently, a study for their affordable housing. So, as that work happens, sometimes there's, I think, a lull in terms of some of the work and the study that's going on, and also the public outreach, and when they circle back with other municipal partners. So we haven't met since before I think the springtime was the last time we met. I certainly hope, and I will follow up with them, Councillor, in terms of when we're meeting next, because I'm certainly eager to get together in a roundtable fashion as well and discuss what their findings are and what direction they're taking on the issue of affordable housing.
Thank you very much. I look forward to knowing more about it in the future. Thank you.
If I may, one of my questions was sort of centering around the housing affordability matter. Ms. Maldacera sort of mentioned that the province had downloaded some of those responsibilities to the lower tier municipalities. So I think one of our next steps might be for staff to share what sorts of things that we can do and how we can start to influence some of those decisions. I know, we as a council, when we're talking to the development community, we reference purpose-built housing and variety of housing stock. but what tools are available to us to start to influence that? Since it's sort of a bit of a, what I'll call it a new responsibility, it might be useful for us to have some further discussions about what our role is for, as Councillor Leahy said, you know, it's something new for us to challenge a little bit further. Up until now, it's always been, well, that's a regional responsibility. So, anything further? Well, we've had quite a busy morning with a lot of information, and I want to thank our three main presenters and Ms. Bégin's team for our morning. Mr. Williams, we did not get a good look at the back of your vest, but that's okay. We'll have to trust that it's there. No twirling? Okay, when we adjourn, we'll twirl, okay. So at this point, I have a motion that was made earlier this morning to receive the presentation. I'm gonna add with thanks, and that was from Councillor Leahy and Councillor Foster. Any questions? All those in favor? That motion carries. I need to do a confirming bylaw. May I have a motion for the confirming bylaw? Moved by Councillor Crone, seconded by Councillor Carruthers. All those in favor? That motion carries. And an adjournment moved by Councillor Foster, seconded by Councillor Crone. All those in favor? Thank you very much, and we are adjourned. Thank you, everyone.